Welcome to week 3 and our lecture on privacy. And you may wonder why we're talking about privacy in a course that deals with decision making. But of course, when we're thinking about who gets the information, who gets informed, who gets the information and has to make a decision, who's not allowed to get the information, and what do we do as a third party when you think that you should probably try to share the information, but you're not sure if you're allowed to or not. So that's why this section is on privacy. And you can follow along if you like with the PowerPoint, which is given to you with the link called Privacy in Older Adults. And so the first slide just says protection of privacy. And there's a quote from the BC Law Institute, which just frames out the fact that privacy has become one of the most pressing issues today, particularly in light of technology and electronic advancements. And for anyone who's ever tried to do any shopping once online, you'll see that all of the many algorithms are following you. You'll know that there's concerns with regards to what your cell phone is recording on a regular basis, what apps are tracking you, but also we should just be concerned generally about the amount of information that gets shared. And so moving to the next slide, which is slide number 3, entitled Federal Legislation, you'll see that there are 2 privacy statutes at the federal level. The first is the Privacy Act, and that's not usually what we think about, but it's about keeping yourself and your information private. And the second is about the Personal Information Protection and Electronic Documents Act, PIPEDA, as I will call it from now on, which is about giving your information out and keeping it private. We'll also talk a little bit about the specific information that's private with regards to health records, and those, again, are a little bit different province by province. So the Privacy Act, which is on slide 4, is a federal privacy act, and it deals with personal information in the federal public sector. So it's a smaller and more narrow piece of legislation. You would think it doesn't cover everything, but it does impose obligations over 200 federal government agencies about respecting privacy rights of individuals. So this isn't really covering a lot of businesses. It's covering the rules for how you interact with the government. And what it also does is it collects and limits information, use of disclosure, personal documents, etc. And it makes sure that that information is kept private in the course of providing those public services. SIN numbers, employment insurance information, etc. would be examples of this. Individuals have the right to see and correct personal information, although you may find that actually quite challenging to do in reality. Turning to the next slide, which is PIPEDA, which is a lot of what we're actually thinking about when we're thinking of privacy. So it's important to know that PIPEDA applies to all organizations engaged in commercial activities. It is a bit of a challenge with regards to not-for-profit organizations or charities. Sometimes they are not covered. Moreover, they're generally not covered by PIPEDA. But just being a not-for-profit does not automatically exempt you from the application of the legislation. As well, a handful of provinces have also enacted their own legislation. And I give the example here of BC's Personal Information Protection Act, which is a provincial version of PIPEDA. It supersedes it. And it, in fact, does restrict not-for-profits. So just because you're a not-for-profit doesn't necessarily mean that you get out of PIPEDA. But what does PIPEDA mean? We talk about it, but what does it actually mean? Well, it's the ground rules about what information is given out in the private sector. So again, the Privacy Act governs the public sector. PIPEDA governs the private sector. And it's all about how you collect information, use or disclose personal information in the course of commercial activities. The federal government can exempt organizations on activities in provinces if those provinces have adopted what we call substantially similar legislation to PIPEDA. So we can say, okay, provinces, I see that you've done your own. It meets all of our requirements. In fact, it may go farther. Again, I give you the example of British Columbia and the BC's version, which is the Personal Information Protection Act. And if it goes further, then that's fine. Then you can use it because it supersedes PIPEDA. What it means is that all across the country, the rules will be at least as stringent as PIPEDA. which means if you don't have provincial legislation, then you use the federal version of it. And what it's trying to do is balance out the right of privacy with the needs of organizations to collect information. So you'll see lots of times that you have to agree to share your information. Moving to summary on page 7 of our slides, it says that organizations covered by PIPEDA have to get an individual's consent. And they don't just have to get a consent once, they have to get it when they collect, use, or disclose the personal information. So if you got consent to only use it but not to disclose it, then you would need another consent. Very commonly these days, any kind of form will cover off all of these. The individuals, again, have the right to access that, and they can ask that the information be corrected. They can only have that information used for the purposes for which it was collected. So if it was collected for the purpose of being in communication with you about health information, they can't sell that information and use it to sell you sofas, for instance. If an organization is going to share that information for another purpose, you have to get new consent. So as an example, a bit less disparate, if you have information collected for your own personal health and care, and you're sharing that information and you give consent so that you want, for instance, one physician to be able to receive information from a psychologist, or you want your psychologist to receive information from your audiologist, you need to give consents generally. There's an exemption for if they're in a circle of care already, but we'll talk a little bit more about that in a minute. But by contrast, if they want to use that information for research purposes, then even if they're doing no new thing, you have to get an individual consent to use that information for research purposes. So it can't be collected for one reason and then used for another without a specific new consent. There's also requirements for how the information is physically kept. So would it be under password protections? Are there locked cabinets? Are there firewalls, etc.? And there's standards with that. And different workplaces will have to have a privacy officer, and a privacy officer is the person in charge of that company, ensuring that the PIPEDA information can be met. So if you have a query, you can ask to be sent to the privacy officer. Who oversees all of this? Well, on slide 8, you'll see that there's the Privacy Commissioner of Canada, and they oversee both the federal statutes, so both the Privacy Act, that's the public stuff, and PIPEDA, which is the corporate or organizational stuff. They also can receive complaints and investigate complaints. They can engage in audits, and they can generally engage in research and knowledge mobilization and outreach with regards to privacy. And they do. Quite often you'll see those quite scathing reports. Having said that, it can be quite difficult to get a hold of the Office of the Privacy Commissioner. I myself can tell you I tried to get a hold of them for several months, and it was a real challenge in order to get a meeting. Slide 9 talks about privacy legislation in general, and again, reminding you that that there are sometimes individual provinces who have specific privacy legislation as well. Turning to slide 10, so you'll see how no matter whether or not they're just using the federal, or in some cases whether they've superseded, there will always be the privacy protections as a minimum standard of PIPEDA. You'll see that BC, Alberta, and Quebec all have their own privacy legislation, and they've all been recognized. Ontario has privacy legislation about personal health information, and I've posted that information as well as a couple of pages which summarizes the Ontario personal health information. Turning to slide 12, you'll see that BC and Alberta's information is laid out here, and it also details on this slide how some small differences are understood between the two of them. This is very technical, and I offer it for your interest. Slide 13 talks about sector-specific privacy legislation. So this is really important for when we're thinking about powers of attorney, particularly because there's requirements on privacy and things like the Bank Act, as well as in particular health records. So if banks, for instance, are going to be sharing information, they also have to get very specific consent and keep the information safe. Even though we've seen privacy breaches in this area, that legislation is very specifically put into the governing legislation of the Bank Act. So not only do they have to look at the PIPEDA they also have to live up to the higher standards within their own financial systems. So we're going to stop there. That's the end of the first video, and we'll continue on with the second video on privacy, which will start at slide 14, financial abuse of older adults, PIPEDA and banking.